what's missing from your operating agreement? There may be things missing that are critically important. I've worked with hundreds, maybe more, of individuals and partners who have operating agreements. I've reviewed them, and I can confidently say that a well-crafted operating agreement is going to be worth its weight in gold when it comes to the smooth running of an LLC, and particularly if things start going south. In this video, I'm going to show you exactly what your operating agreement should include to protect your business and avoid future headaches, litigation, fights with your partners. I hear all the time, do I need an operating agreement? Yes. Are you legally required to have an operating agreement? No, you are not. If you don't have the operating agreement, you're going to be held to default rules that are established under state law. You may not like those rules. Plan ahead. It should be one of the first things you do before you're even putting money into the company, is getting your operating agreement terms worked out. It is going to make things so much easier for you and keep the decision in the owner's hands, not in the hands of a judge, if it ever gets there, in a dispute or arbitrator. Having worked with hundreds of business owners and reviewed countless cases, disputes, I could say that the cornerstone of your LLC is an operating agreement. It's got to be well crafted and it has to be thought out. And the truth is, agreeing on these critical decisions with your partners up front prevents the disputes, prevents the spiral, prevents costly and messy conflicts. Have the discussion at the beginning. What I found is sometimes people don't agree. They can't come to an agreement even on the operating agreement. You know what that says? Not a good partnership. You dodged a bullet, right? Because later on down the road, trying to get someone to agree already when the cake is half baked, whether we're going to make it chocolate or vanilla, is really challenging. Let's figure out what the ingredients are in your operating agreement right at the start. Our LLCs, every single one of them, we give you a great operating agreement and also give you the opportunity to purchase a custom operating agreement based on the needs of the particular owner. So I encourage you to check that out. This is not comprehensive, right? I want to make sure you understand that. There are things you may want to or need to include in your operating agreement that aren't covered here, but these are the basics. These are the things that everybody should have in their operating agreement. So let's get into it. The company name and purpose, right? What is the official name of the company and what is the business purpose? Your company name you would have put into the Secretary of State records, but it's got to identify the company name in the operating agreement, or else what are we even talking about? Does this operating agreement apply to the company we formed? The business purpose is one that there's some wiggle room on this one. There's really two approaches. One approach is going to be, you say that this company can engage in any lawful purpose. Anything that's allowed under state law, this company can do. That may be great. It could also be a problem, right? So let's say you're going into the business for the purpose of investing in real estate. You're forming a partnership. If it doesn't say that the sole purpose of this business is going to be invest in real estate, your other members, the other folks involved with the business could say, you know what, we want to open up a taco truck. I always do taco trucks. And so then the business, if you're a member and you don't have enough voting power, it could be that you're now in the taco business. You had no intention of being in the taco business. So it may be important, depending on the owners, depending on the flexibility you want, to either state the business purpose or to perhaps restrict it, or I should say, to state a specific business purpose, or perhaps leave it wide open. That's a decision, something you need to talk to your partners about. Ownership structure. Who are the members? What are they putting into the company at the start? What are their ownership percentages? It's critical. It's called the capitalization table. It goes by a bunch of different names, roster of investors, but do we know what each person's ownership percentage is in the company and what they have contributed to the company? This ties into our capital contributions. What are those initial contributions someone's putting into the company to get their ownership percentage? And then what happens in the future if additional funds are needed? It's rare that a company starts up, you put in a couple of bucks and then it makes money. It's just a cash cow from then on. If additional funds are needed, do they come in as loans? Is everyone required to put in money? What if I can't do it? Do I lose my ownership percentage? What happens if additional money is needed, as well as what happens at the beginning? Another critical point is your management structure. I default to manager managed, okay? Manager managed means that you could have 10 members, but those 10 members appoint a smaller number, usually, of managers who are authorized to take actions on behalf of the company. I prefer manager managed. I also think that there is a place for member managed. Members managed means that every owner, whether they have 2% or 90%, has the authority to manage the company or make decisions. It's member managed. They have a certain level of authority that comes with that member management. I prefer manager managed, and then I also prefer I recommend you include is, what are the responsibilities of the members or the managers? What authority do they have? Suppose they want to go out and buy a Ferrari in the name of the company. Could they do that? Or is there some restriction on it? What are the voting rights is the next area we need to consider. Does everyone have the ability to vote? Everyone, perhaps managers, perhaps members, are there voting members, non-voting members? How many members must vote? Does each member get one vote? Is it based on their ownership percentage? What ownership percentages are required? Do we need just a majority, 51%? Do we need 75%? Do we need unanimous? What does it take to make important decisions for the company? What is the voting? Profit and loss allocation is the next. So distributions, are they required? Are they discretionary? So if the company's got $1 million in the bank and, partners say, we're not going to give any money to the owners. We're not going to distribute it to them because we are thinking we're going to invest in a whole taco truck franchise. Always tacos with me. Then are there forced distributions? Are there mandatory distributions? Are they quarterly? Are they monthly? Are they annual? Those are the things to keep in mind when you're generating or creating your operating agreement, so everyone's on the same page. Banking and record keeping. Who has authority over bank accounts? Who's responsible for maintaining the business records? Where are those business records maintained? Who gets access to the business records? Are the members, the managers? Who is it? So lining up all of those things in advance will avoid those disputes later on down the road. Speaking of disputes, how do we resolve disputes? And sometimes you got a 50-50 partnership, right? There's two people involved. How do you settle disputes? Is there a third party? Do we say we all trust our friend Steve? Steve knows both of us. We know he's loyal to both of us. We're going to go to Steve whenever there's a dispute. Do you say that we go to an arbitrator? Do you say that, we flip a coin? Whatever it is, how do you resolve those disputes should be laid out in the operating agreement. One of the core considerations or the reasons to have an LLC is to be able to pick your partners, okay? I want to go into business with my friend Steve. I hate his brother-in-law, Elliot. If Steve can just sell a portion of his membership interest to his brother-in-law, Elliot, I would be forced to be a partner with Elliot, and I don't want to be a partner with Elliot. So you should have membership change rules. Can someone sell or transfer their interest to somebody else? Do they need approval to do it? Okay, go ahead. Sell it to whoever. I don't care. I'll partners with Elliot. I get along with everybody. Thinking about those things, what are the rules for adding members, removing members, transferring membership interest? What do you pay? Forced buyout? All of those things related to those changes in membership should be clearly identified in the operating agreement. Dissolution. Sometimes businesses don't work out, right? Sometimes you may have something that says the members, you can't leave the partnership. As long as the partnership's around, as long as we got this company, you are going to be a member of it. What are the rules for dissolution? Suppose we want to get rid of the company. One partner, he does not want to be involved anymore, and the other partners they're bullying him or her. And so you say, what vote does it take to dissolve the company? And you can say maybe it's only a majority vote. Maybe it's I usually don't recommend a unanimous decision because that does allow one individual to sort of hold the company hostage if things really aren't working out and there are disputes that are unresolved. And so what are the dissolution terms? You should definitely have that inside of your operating agreement. And then this last one is tricky. Amendments to the operating agreement. How is the operating agreement changeable? And I think that this is the one that can really come back to bite you. Because if you're a minority partner, you've got less than 51% of the company, but it only takes 51% to change the operating agreement, then you could sign up on day one and say, okay, this is great. This really satisfies all the, everything I was looking for. I'm really well protected. And then the next thing you know, operating agreement has changed and all of your rights disappear. And so when it comes to amendments to the operating agreement, you got to be really careful about what it takes. When it comes to those kinds of changes, I almost always recommend unanimous decision is required to amend the operating agreement to protect the rights of those minority or those small ownership holders. So this has been really an analysis and a discussion of what should be and what really must be included in your operating agreement in order to avoid any disputes in the future. There's obviously a lot of other things that should be or could be included in your operating agreement, but this is really just a summary of what I think is most important and where I see the most issues. Stay tuned for additional videos about operating agreements and other things that are important for you when it comes to managing your business.